Section 1.2 Sources of Criminal Procedure Law. The legal foundation for most criminal procedural decisions is the United States Constitution, including the Bill of Rights and the 14th Amendment. The Bill of Rights sets forth 23 individual rights, and the 14th Amendment's guarantee of due process has been interpreted by the United States Supreme Court to incorporate many of the individual rights contained in the Bill of Rights. The Bill of Rights originally was conceived as applying only to the federal government. During the 20th century, the Supreme Court interpreted the Due Process Clause of the 14th Amendment as including or incorporating many of the individual rights contained in the Bill of Rights, this making these rights applicable to the states. These include most of the procedural criminal provisions of the 4th, 5th, 6th, and 8th Amendments. Incorporation means that the individual right, such as the 4th Amendment right to be free from unreasonable searches and seizures, is included in the 14th Amendment's guarantee of due process or equal protection. Rights incorporated in the 14th Amendment are those the court has deemed fundamental. These rights are applied against the states and include most of the criminal procedure-related provision of the 4th, 5th, 6th, and 8th Amendments. Other sources for criminal procedure law are state constitutions and federal and state statutes. States are free to provide more individual rights than the federal Constitution, but states cannot deny or diminish any federal constitutional rights. In the past, states were seen as perhaps less protective of the rights of criminal suspects than the federal government. Yet in the last 2 decades, a number of state courts have interpreted their state constitutions as providing greater protections of individual liberties than the federal government. To say that a piece of legislation passes constitutional muster is to say only that it passes minimal standards of fairness. Other sources of criminal procedural law come from the provisions of the Bill of Rights, in particular the 4th, 5th, and 6th Amendments. Courts frequently are asked to interpret the meaning of these amendments and to apply them to current fact situations. The 5th Amendment prohibits compelling people to testify against themselves, but does requiring a person to take a breathalyzer test or give a blood sample constitute testimony when the results may be used against that person at trial. The 4th Amendment prohibits the unreasonable seizure and search of persons, places, and effects. But what is an effect? And what is unreasonable? Courts must answer these questions to determine when the police have exceeded the scope of their authority, either intentionally or unintentionally. The United States Supreme Court has the final word on the constitutionality of any state action that is challenged as violating a constitutional right. Consequently, much of criminal procedure law comes from Supreme Court decisions. As courts decide only the case before them and do not issue policy directives, criminal procedure law has developed fitfully on a case-by-case basis. Much of criminal procedural law has been written in the past 75 years, since the Supreme Court began to apply the provisions of the Bill of Rights to the states, which conduct the bulk of criminal investigation and prosecution. In this book, we focus on Supreme Court decisions involving criminal procedure and use lower court cases to illustrate the principles enunciated by the Supreme Court. Before we do this, however, we need to discuss the role of the judiciary in criminal justice.